Related party transactions. Okay. For current account transaction, make it FEMA kaduga. Directors and okay. So you are in directors and KMP, right? So shall we start? ఏంటమ్మా డబల్ అయినట్టున్నారు స్ట్రెంత్, లేదా వేరే బ్యాచ్ వాళ్ళైనా వచ్చి కూర్చున్నారా? అమ్మా న్యూ కమర్స్ ఎవరైనా ఉన్నారా? ఉన్నట్టే ఉన్నారు. స్టాండప్ వన్స్. న్యూ కమర్స్ ఈ ఒక్కసారేనమ్మా నేను మిమ్మల్ని నుంచోమని అడిగేది. మీ వయసు రీత్యా ఇంకెప్పుడు మిమ్మల్ని నుంచోమని చెప్పను. దిస్ ఈజ్ ద ఫస్ట్ టైం. ఈసారికే తిట్టుకుంటున్నారు జనాలు. వెరీ గుడ్. వాట్స్ యువర్ నేమ్? when did you completed your cmainter? Very good. From? Okay, same pro forma name. When did you complete cmainter? From December. Okay, right. Guntur. Very good. Sit down. ఎందుకమ్మా అంత కోపంగా చూస్తున్నావు? నేమే కదమ్మా అడిగాను నేను. June 25. Okay. From? Okay, right. Sit down. పేరు వసంతమ్మ. వెరీ గుడ్. కూర్చోమ్మ. రైట్. సుభాష్. ఉస్మాన్. ఓకే. వావ్, సూపర్, ఎక్సలెంట్. ఓకే, రైట్. సెల్ఫ్ స్టడీ కాబట్టి ఇన్స్టిట్యూట్ ఉండదు. ఇమ్రాన్. ఓకే. సేమ్ కంబైన్ స్టడీసా మీరిద్దరు? ఓకే, రైట్. ఆసిఫ్. 25, recently passed out. Very good. From? Okay. Upendra. Okay. Oh, super. Okay. Right. Congratulations, ma. Self study ఎక్కువ మంది ఉన్నట్టున్నారు. Wow, super. So we just started paper number 13 and we started with which chapter, ma? Chapter 5 of Companies Act, Directors and KMP. And the previous sessions are completely related to first session, syllabus structure and the teaching order. So if anyone didn't watch the videos, they are available in YouTube live session. First of all, complete that live session videos, ma. Okay, right. So in directors and KMP, first of all, director definition and what are the roles of a director in a company, and next classification of directors and maximum number and minimum number, and what is our earlier discussion, ma, in previous class, which topic we didn't completed. So how to obtain DIN, what is the process to obtain DIN, we have completed. I think after DIN we have to complete appointment process of director. So appointment of first director, appointment of second and subsequent directors we have to complete. We will complete in this session today. So director section 2 subsection 34, director is a person who is appointed to the board of the company and 5 roles are there to perform as a director in a company. What are those 5 roles, ma? First one, he should act as a fiduciary personality. In fiduciary position he has to act. And the second one is what? Decision maker and strategic planner, representative, compliance officer. These are the 5 roles to perform as a director in a company. And minimum number, maximum number, OPC 1, private company 2, public company 3, maximum 15. There is no hard and fast rule that there should be no directors beyond 15. Yes, you can appoint more than 15 also, but in order to appoint more than 15 directors, beyond 15, for 16th, 17th, 18th directors, you have to pass special resolution. That means you have to give the proper justification to your shareholders, saying that we need more number of directors beyond 15. For that purpose, special resolution is to be passed. Okay. And after that, classification completed and DIN also completed. What is the general route to obtain DIN? Filing which form? DIR3. Fees is 5,000, right? 500 or 5,000? Pakka? 500. Very good. What is the other route to obtain DIN? Spice Plus. What is Spice Plus? Specific pro forma for incorporation of companies electronically. Okay. But in Spice Plus form, maximum 3 applicants can be accommodated in Spice Plus form. So that is why DIR3 is the general route to obtain DIN. Okay. So why DIR3 before DIR? What is the role of DIR1 and DIR2? I have already communicated. DIR1 is discontinued, ma. So DIR1 is the form which is available in old Companies Act. So whenever new Companies Act came into existence, DIR1 discontinued and we are using DIR3. What about DIR2? Consent of a person who is proposing to be act as a director in a company. So whether his appointment will become successful or not, it is immaterial. So if a company is considering his candidature or her candidature, a person's candidature, the company is considering a person's candidature for the role called director, then the person should give the consent in DIR2 saying that yes, I am ready and willing to act as a director in your company if the appointment procedure went well. It is in shareholders' hands only whether they will appoint or not, no one knows. Okay, so that is related to DIR2 and DIR3 digital digital signature, no, DIN application form, application to obtain DIN. So, and what are the documents to attach DIR3? First of all, ID proof you have to attach, address proof you have to attach, digital signature you have to attach, and digital signature of a professional. So what is the role of professional in DIR3, ma? Professional has to give a declaration. Professional means CA, CMA, CS in practice. They have to give a declaration saying that yes, we have verified the profile of this person, ID proof, address proof, we have verified. Everything seems to be okay. So that is the declaration. That is what we call professional declaration. Professional declaration, CA in practice or CMA in practice or CS in practice, they have to give. They have to attach the digital signature also. And one of the important document is there to attach DIR3. What is that important document? Board resolution proposing your candidature for the role called director. So DIN number can't be obtained by a person on casual basis. What is casual basis and what is serious basis? We have completed in the previous session. Majority of the persons will obtain PAN on casual basis, but that is not the case with respect to DIN. DIN on a serious note you have to obtain. That means whenever DIN number is allotting by MCA, you have to be very serious. Huh? What is meant by serious note? What is meant by serious note and what is meant by casual note? Tell me. What is meant by serious note means, say for example, if no company is considering your candidature, no one approached you for the appointment as a director, no one approached you, just because on a casual way, on a futuristic basis, unte manchidi kada. So on a futuristic basis, you obtain, so you are making an application to MCA, Ministry of Corporate Affairs, saying that, sir, I have attached all the documents, sir, please allot me DIN. No, they don't allot on a casual basis. In order to allot DIN, they will verify one crucial document. What is that crucial document? Is board resolution. What is that crucial document, ma? Board resolution. That board resolution is passed by board of directors of the company, and that board resolution, the matter to be contained is they are seriously considering your proposal for the role called director. They are not saying that yes, 100% we are going to appoint you as a director. They are just considering your profile. They are considering your candidature for the role called director. There is no assurance that you are going to be appointed as a director of a company or not. Why? Because it is in the hands of members of the company, not in the hands of directors of the company. So one board resolution you have to attach with DIR3. Sir, so and so company is considering my profile, sir. That is why please allot me DIN number, sir. Then MCA will allot you DIN. On a casual basis, sir, for futuristic purpose, I am asking, sir. No one is actually considering as of now, sir. In future, anybody may consider, sir. That is why please allot me DIN now, sir. No. If anyone actively considers your profile for the role called director, then we will give DIN. Then make application. Then we will consider. DIN how many digits, ma? 10. 8 digits, alphanumerical one. 8 digits. DIN. Okay. So this is all about DIN, and we have discussed the cases where surrendering DIN. In what kind of cases you can surrender your DIN? That is also we have completed. No. Rotation. Yes. Surrendering DIN. Yes, these are the cases where you can surrender your DIN. First one is what? Fail to appoint as a director, then you can surrender. There is no obligation that whenever your application failed, you have to surrender DIN. No. Say for example, X Limited directors proposing me as a director to appoint in the general meeting. They are considering my profile. They communicated the same. I don't have DIN number. On immediate basis, I have applied to MCA for DIN number by spending money, 500 and all, and MCA immediately allotted me DIN number to me. But the application turned out to be a failure. Shareholders rejected my candidature as a director. Then there is no hard and fast rule that I have to immediately surrender the DIN number to MCA. No need to do. There is no hard and fast rule. If I wish to surrender, I can surrender. That is the provision. Understand the spirit of the law. Don't think that, okay, whenever a person failed to appoint as a director, they have to go to MCA and surrender the DIN. No, that is not the rule of the law is saying. Rule is saying that if you wish to surrender, you can surrender. Sir, I don't want to surrender. Okay, you can hold. You can hold. So even though you are not a director, DIN is there for you. That is case number 1. Case number 2, you have multiple DINs. By mistake or intentionally or unintentionally done, by mistake MCA allotted multiple DINs on your name. Multiple DINs on your name. Then as and when it came to your knowledge saying that on your profile multiple DINs are mapped, it is your responsibility to communicate MCA saying that, sir, multiple DINs are mapped to my profile, sir. This is my active DIN number. Please cancel this DIN number. That is your responsibility. You have to communicate to MCA. That is second point number 2. And the third point is person deceased or unsound mind or insolvent. Person died. What is the purpose of DIN number? No, you can surrender. You can surrender. Can means there is a possibility you can surrender. So obviously your legal heirs or whoever it may be, they can surrender. There is no hard and fast rule that they have to surrender. Law is not imposing any obligations. Sir, then how come Ministry of Corporate Affairs will came to know that the person died, sir? Very simple. Annual KYC point is there, no? Don't you remember that annual KYC point? If you have DIN number, each and every year you have to update the KYC. Say for example, person died. Who will update annual KYC? No one will update. Obviously, MCA will cancel the inactive DIN numbers. Very simple. Point of common sense. Okay. Next one. Third one. Fourth one. No longer acting as a director in any company. So say for example, you are no longer acting as a director in any company and you wish to surrender. You wish to surrender. No, there is no hard and fast rule that you have to surrender. You wish to surrender, then you can. Okay. So these are the 4 cases where a person can surrender his DIN number to MCA, Ministry of Corporate Affairs. These are the things we have completed. Disqualifications, qualifications and disqualifications completed. Section 164, 1, 2, 3. Tell me 164, 1. Personal disqualifications. 2. Company level disqualifications. 3. AOI disqualification. ఇక్కడ ఒకడు ఉంటాడు రా, వాడు ఏడి ఇక్కడ కూర్చుంటాడు వాడు. నువ్వేరా స్పెట్స్. ఏంట్రా వెనక్కి వెళ్ళిపోయావు? ప్లేస్ లేదా? లేట్గా వచ్చావా? ఇగో నువ్వు ఇక్కడే కూర్చోవాలి. వీడున్నాడు కదా, నువ్వేరా. సో నువ్వన్నా ప్లేస్ సాక్రిఫైస్ చేయలేదా, కొంచెం అడ్జస్ట్ అవ్వండి, వాడు అక్కడే కూర్చోవాలి. ఓకే. ఏం పేర్రా నీ పేరు? ధీరేంద్ర. వెరీ గుడ్. ఓకే. Active listener ma, that is why. Okay, I am not having any pecuniary relationship with that guy. Okay, I don't even know his name. Right, next one. So disqualifications also completed. Now let's consider appointment process of a director. Appointment, reappointment, rotation. Let's complete today appointment, reappointment, rotation. Simple concepts in directors chapter, very simple. So listen. This is all about appointment and reappointment. Simple flowchart relating to appointment of directors and reappointment of directors. Listen carefully. So first of all, we'll talk about appointment. Okay. Everyone sit properly first. ముసలోళ్ళ కూర్చోవద్దమ్మా, సరిగ్గా కూర్చోండి. First of all, we are talking about appointment. So appointment of first directors, very simple. Sir, who will act as first director, sir? No one knows. Go and ask AOA, Articles of Association. In that Articles of Association, at the time of incorporation, you will prepare AOA, no? MOA and AOA you have to prepare. At AOA, you have to mention who will become first directors of the company. If any names are specifically mentioned saying that so-and-so Subbarao, Pullarao, Ellarao acting as a directors of a company, that Subbarao, Pullarao, Ellarao will become the first directors of the company. Sir, AOA is silent, sir. AOA didn't specifically mentioning any names to act as a first director, sir. Then go to association clause in MOA. Which clause? I think in cmainter you studied Companies Act basics, right? MOA and AOA. Tell me the clauses in MOA, ma. NROCLA, NROCLA. NROCLA, name clause, registered office clause, objects clause, capital clause, liability clause, association clause. This registered office clause is there, no? NROCLA, name clause, registered office clause. This registered office clause may also be called with another name called situation clause. So NROCLA. That A is there, no? Last A. A for association clause. In this association clause, who are the associates of the company? Who are the subscribers of the company? The list of the subscribers of the company will be mentioned in that association clause. Will be mentioned in that association clause. In that association clause, who are individuals? Let's find out who are individuals. Individuals like you and me, human beings. That human beings will become first directors of the company. Automatically every human being, every individual subscriber will become first directors of the company. Why? Because AOA is silent. It is the responsibility of the persons who are incorporating the company. They have to clearly appoint first directors of the company. Who will act as first directors of the company just after incorporation? It is their responsibility. They have to fill the names. If they fill the names, everyone will happy. Sir, AOA is silent, sir. In that clause, no names were filled, sir. That position is vacant, sir. No persons are specifically mentioning as first directors of the company. Then go to MOA, association clause. Find out the individuals. Sir, why only individuals? You very well know. Why only individuals? In order to act as a director of a company, only natural persons are eligible, qualified. Body corporates are not qualified. One blind person can't show a proper way to another blind person. You are a body corporate, you don't have mind. You may be a person in the eyes of law, but you are not a natural person. That is why body corporates are not allowed to act as directors. Only who are allowed? Natural persons. Natural persons are allowed to act as directors. That is why you have to go to MOA, Memorandum of Association, pull out the clause. Which clause? Association clause. Find out the names, individual names. Those all individuals will become FDs. FD means first directors of the company. So listen, appointment of FD, the public company or for private company, will be decided by AOA. If AOA is silent, all Indian subscribers will become Indian subscribers, individual subscribers, subscribers who are human beings, natural persons. They will become first directors of the company. Sir, what will be the situation in case of OPC? In case of OPC, the person who is starting the company will automatically become the first directors of the company if AOA is silent. If AOA is directing someone to be acting as a first directors of the company, obviously that person will become the FD of the company. If AOA is silent, the person who is incorporating this OPC, one person will be there, no, to incorporate OPC, that same fellow will become first director of the company. Are we clear? I'm talking about FD, not SD, subsequent directors. So we didn't complete SD as of now. We just completed the discussion relating to first directors. First directors of OPC, very simple. Person who is starting the OPC will become FD. First directors in case of private and public company, this is also very simple. Go and knock the door of AOA. If AOA tell any names saying that these persons are FDs, okay, they will automatically become first directors of the company. AOA is silent. AOA is not specifically mentioning any names as FDs. Then automatically go to MOA. Which clause? Association clause. Which persons? Individuals, human beings, they will automatically become FDs of the company, first directors. This is first point. Second, subsequent directors. Subsequent directors, say for example, private company, obviously AOA has to mention. If AOA is silent, the same procedure which we follow in public company case, the same procedure we have to follow in case of private company also. Sir, why always we are knocking the door of AOA, sir? MOA, what to do? AOA, how to do? AOA talks about internal affairs of the company. That is why the other name for AOA is internal constitution. For every country, constitution is very important, right? For company also, AOA and MOA very important. My MOA decides the relation with external parties, third parties. AOA talks about internal constitution. That is why every time you are knocking the door of AOA, whenever a question arises, go and check what AOA says. Sir, I don't know how to prepare AOA, sir. Nothing wrong. No one knows. Go and copy paste whatever the content that is there in table A, B, C, D, E for MOA. Next 5 clauses for AOA. Okay. Next one. So, sir, what is the procedure we need to follow to appoint subsequent directors for private company? You have to follow as per AOA. If AOA is silent, same appointment process as mentioned for public company. So now we have to know what public company is mentioning. So in case of public company, subsequent directors will be decided by members in general meeting. It may be AGM or EGM. That is why AGM didn't mention general meeting, they mentioned general meeting may be AGM or EGM. General meeting may be annual general meeting or emergency general meeting. Emergency general meeting. My EGM means what, ma? Some fellows will remember like this only, emergency general meeting. And in return, they will argue, sir, EGM means not extraordinary general meeting, sir, emergency general meeting. Yesterday, one fellow is texted in Telegram. Oh, what is his name? I'll tell you just a minute. SM. No name specifically mentioned. SM. The name is SM. With respect to FEMA, he is arguing. Okay, sir, whatever the point you purported or communicated in the class, I think it is not correct, sir. The correct interpretation is like this, sir. Who told you this interpretation? One repeated faculty told this, sir. Then follow that faculty only. So if you need more clarity with respect to this point and all, magazines ma. In FEMA, LRS point is there, liberalized remittance scheme. Liberalized remittance scheme, actually FEMA won't allow sending money abroad for the purchase of banned magazines. Whatever the magazines banned by Indian government, Indian citizens should not access that kind of magazines. Some magazines are there, anti-Hindutva, anti-Indian propaganda magazines are there. Lot of magazines are running, even Washington Post in US, UK, lot of magazines, lot of newspapers. Till today, they will cry on the growth of India. Because we became 4th largest economy. So, okay. So, lot of reasons are there, and lot of pornographic content magazines are also banned by Indian government. They used to circulate a lot. Indians used to contribute so much to that industry. But nowadays, that magazines are banned by Indian government. So, but few Indians will send money to abroad exclusively to purchase this kind of magazines. Then the spirit of the law is defeating, right? For what purpose Indian government banned these magazine circulation? To avoid unnecessary conflicts. Why? Because, say for example, anti-Hindutva agenda, say for example, one magazine is running just to propaganda or criticize Hinduism, or it is unnecessarily causing disturbance in the harmonial environment. It is unnecessarily causing Hindu-Muslim conflicts. That is why government specifically banned this magazine. That magazine is operating from Pakistan or Bangladesh, and few Indians are accessing that magazine content and all. So, in order to restore the harmony, Indian government banned these magazines. That is the spirit of the rule. That is the point in FEMA. One faculty, the video is still available in YouTube. I don't want to name, specifically mention or point out the faculty. That faculty told in the class that magazines means bullets we are using in gun. Magazines means bullets. తెలుగు సినిమాల్లో చూడలేదమ్మా, మ్యాగజైన్ దింపేస్తాను అంటాడు కదా వీళ్ళను. సో దట్ ఫ్యాకల్టీ టోల్డ్ టు ఆల్ ద స్టూడెంట్స్ దట్ మ్యాగజైన్ మీన్స్ బుల్లెట్స్. ఇస్ దేర్ ఎనీ కామన్ సెన్స్? ఆర్ యూ యూజింగ్ గన్ ఆర్ యామ్ ఐ యూజింగ్ గన్? సో ఫర్ వాట్ పర్పస్ వీ విల్ పర్చేజ్ మ్యాగజైన్స్ మా? Actually, as per Arms and Ammunition Act, purchasing or dealing, buying, selling of arms and ammunition by Indians is not allowed. Why? Because we civilians are not supposed to use magazines and use guns and bullets and all. That faculty told to all the students that magazine means guns and bullets. And this guy is underwent coaching in the previous attempt, June 2025 attempt. He underwent coaching under the faculty. Now he is correcting me. Sir, magazine mean bullet, sir. My sir already told, sir. That's why you again came to our college for coaching. నీ కోచింగ్ ముందే సరే గేడ్ ఇస్తే మళ్ళీ ఎందుకు వస్తావు ఇక్కడికి? సో హీఈస్ కరెక్టింగ్ మీ, హీఈస్ ఆర్గ్యూయింగ్ మీ యాక్చువల్లీ. ఎస్టర్డే హాలిడేనో, ఐ థింక్ హీఈస్ వెరీ ఫ్రీ. దట్ ఈస్ వై హీఈస్ అన్నెసర్లీ కన్జ్యూమింగ్ మై టైమ్. సార్, magazine means bullet, sir. You misinterpreted. Starting the company will become the first director. In case of public company or private company, who will become first director? Depends upon AOA. If AOA is silent, all individual subscribers who is subscribing to MOA, they will become first directors. And what about second and subsequent directors? In case of private company, in case of public company. First of all, in case of private company, you have to go through AOA. to know about the process mentioned in AOA. Sir, some process is mentioned, sir. Okay, follow the process. Nothing is mentioned, sir. Follow the same process which is happening with public company. What is the process happening with public company? Members are entrusted with the powers to appoint directors of the company. So you have to follow the same process. So members of the company has to appoint the directors. So this is the thing. Appointment of first directors and appointment of second and subsequent directors. Now, if company is considering a person's candidature to appoint as a director, then what kind of documentation this guy needs to give to the company? He has to submit 3 important documents. Mandatorily has to submit, mandatorily have to submit these 3 documents. Very, very, very important. Kindly observe and understand. First of all, you very well know this point. DIN, Director's Identification Number. How to obtain DIN also you very well know. By submitting DIR3 or Spice Plus form, both ways you can follow any way. But if you wish to access Spice Plus form, you have to start a company. DIR3 is the regular process. That is why we mentioned in handwritten notes also. DIR3 is the regular process. There are 2 ways to obtain DIN. First, Spice Plus form DIR3. What it is, ma? What it is? Regular process. DIR3 is the regular process. Okay. So, back to the discussion. Appointment. Director has to submit mandatorily 3 documents. First of all, DIN. You very well know this point. Second, particulars of interest in other businesses or other entities. Director has to submit POI in other entities. What is POI? Particulars of interest. Say for example, sir, I am holding 10% ownership in so and so company, 15% ownership in so and so company, 50% in so and so partnership firm. So by accessing this particulars of interest, the remaining board of directors, the management of the company will came to know he will become a related party or not. So to determine that purpose and all, he has to submit this POI in other entities. Particulars of interest in other entities. Sir, I am having shares in this company. I am having shares in that company. I have this much of ownership in this partnership. I have this much of ownership in this LLP. Why? Because, say for example, listen. Company wishes to appoint Mr. X as a director. X as a director. Mr. X is 60% beneficial owner in so and so LLP. One LLP is there. In that LLP, X is the beneficial owner up to 60%, majority partner. Now, company is entering into a contract with that LLP. If X didn't disclose saying that, sir, I have 60% ownership in this LLP, how come directors will know, ma? Are the directors are disciples of Potuluri Veerabrahmendra Swami? Do they have any Kalajnana mechanism and all? Law kallu musukoni itla telisipotundamma. Valకేం తెలుస్తుంది? So it is your responsibility to disclose the particulars of interest in other entities. It may be a sole proprietorship, it may be a partnership firm, it may be LLP, any other company, private company, public company, OPC, whatever the interest you are holding with other companies, it is your responsibility to disclose. Section 184 is saying, sir, if deviate, what will happen, sir? I don't disclose, sir, what will happen? At the time of 184, I'll tell you what will happen if you don't disclose the particulars of interest properly. And at 184, we can elaborately discuss this POI point. First of all, kindly remember this point as, yes, the director has to submit POI. POI means particulars of interest in other entities. Kindly remember this point, okay? First point is what? Director's identification number. Second point, particulars of interest in other entities. Third point, you very well know, DIR2. Consent letter. DIR2 is nothing but consent letter. Yes, if your members appointed me as a director for your company, I am ready and willing to act as a director of your company, and I am not suffering with any sort of disqualification purported in section 164. So this is the declaration you have to give to the company. And in turn, company will file the same declaration to MCA. That means ROC is there, no? Company husband is ROC. For everything, company will access the permission of ROC only. Registrar of companies. So company has to intimate the same declaration to ROC. So this guy is saying that he is qualified enough. He is not having any disqualification. That is why we are appointing. If any discrepancies are there, kindly check by yourself. Then by entering the same DIN number and all, MCA website database servers, it will alert immediately if that guy is suffering with any disqualification. Clear? 3 documents clear? Tell me the 3 documents. DIN POI DIR 3. 3 and 2 anything we can use, ma. DIR 3 means what? You are making application to MCA and requesting MCA to kindly allot DIN. Here DIR 2. You are saying to company that yes, I am qualified enough to act as a director. I don't suffer with any disqualification. So DIR 2 is a declaration. DIR 3 is an application. Both are not same. Okay. So DIR 2 is a declaration. DIR 3 is a application. Clear? 3 documents. First one. Director's identification number DIN 2. Particulars of interest in other entities, other businesses, whatever it may be. Third one. Consent letter to act as a director, DIR 2. So these are the 3 documents which director mandatorily submit to the company whenever he is undergoing appointment process of a director and all. Okay. Are we clear? I just confirmed that after that company should file DIR 12 to MCA within 30 days. This guy is saying that he is not suffering with any disqualification. If any disqualifications are, kindly check by yourself. We are believing this guy. So like that, company will in turn communicate the declaration filed by the director, not director, proposing director to MCA. In which form? DIR 12. DIR 12 is very important, ma. You are going to study this DIR 12 again and again. Kindly remember this number. DIR 12, MGT 14, DIR 12, these are few important forms. What is MGT 14? I'll tell you at a later point of time, not now. Okay. So are we clear with appointment of director? Appointment of director clear. Appointment of first director, appointment of subsequent director for a private company, for a public company, for OPC. Now let's carefully consider class in into 6 5:37 around. Okay. Few minutes are there. Yes, time is enough to complete reappointment process and all. So let's check out this rotation process first. Rotation process. Sir, what is meant by rotation of directors? Very simple, ma. Appointment and reappointment material reading not completed, right? Let's complete first material reading first. This one. Appointment, reappointment. After that, rotation I will tell. So, appointment of first directors. Which company? Private company or public company other than OPC. Why for OPC? The person who is starting the company will automatically become the first director. So only one director is mandatory. The sole member is deemed to be the first director until the company appoints a director as per 152. This is the case of OPC. Let's check out the case of private company or public company. First directors are appointed as per the AOA. If AOA is silent, then all subscribers to MOA will become first directors. Okay. Subsequent appointment of directors. Subsequent means after incorporation. In public company, directors are appointed in general meeting by every person proposed to appoint must furnish DIN number, file a declaration that he is not disqualified. POI missed, that's why I included in handwritten material. Next, in private company, it is similar to public company unless articles provide different mechanism. That means how to appoint directors in private company, it is the responsibility of the AOA to mention. If AOA is silent, please follow the mechanism purported in public company. More flexibility is given to private companies under section 5. So some rules are there, you no need to private companies are no need to follow that rules and all. Simple example I'll tell you with respect to these rules. I have already told this in a previous session. Many people forgot. Congratulations. 1 lakh deposit. 1 lakh deposit point clear, amma? Listen. In case of public company, to avoid unnecessary noise or unnecessary disturbance, in case of selection of directors and all, company will put a monetary limitation. What is that monetary limitation? Very simple. Whoever wish to participate in the election process of directorships, they has to submit 1 lakh as monetary deposit to the company. Minimum is 1 lakh, maximum company wish 2 lakhs, 3 lakhs, 4 lakh company wish. Minimum is 1 lakh. They have to put monetary deposit point 1 lakh. Say for example, this is the general meeting of the company. This is a general meeting of public company. More than 7 members are there, no? Happily. So you are conducting a general meeting of a public company. Very good. Now election process starts. Everybody is participating for the role called director. Everybody. Then who will vote? No one knows. Everybody will vote for themselves. Only one vote will be casted. So majority of the people are participating for the position called directors. That is why in order to avoid this kind of situation, company came up with a rule saying that whoever wish to follow in the election process, yes, openly welcome. Anybody can participate, but they have to deposit 1 lakh as monetary deposit. Refundable only, refundable. But the money will be refunded to you only at least a certain percentage of vote are cashed in your favor. At least 20%, if you are able to manage to get 20% of the voting, then your monetary deposit will be returned to you. Otherwise, the monetary deposit will be forfeited simply. Then what will happen? Majority of the applicants will be withdrawn. Obviously, company is getting benefited due to this. That is why to avoid unnecessary noise and unnecessary delayed process in the appointment mechanism, for public companies, these monetary deposit rules are applicable. But that is not in case of private company. Those rules are relaxed. Likewise, few administrative rules are there. None of your business. Why? Because those points are not included in your syllabuses and all. That is why I am avoiding this discussion. Okay? This is the significance of the point. What is the point, ma? More flexibility is given to what companies? That means some sort of rules company has to follow in case of public company. If you are appointing, if you are considering to appoint directors of a public company, stringent process is there. But flexible process is there for which company? Private company. Next. In OPC, the single member can appoint a director. No requirement of AGM. Only one person is there. Is there any necessity to conduct AGM? Who will participate in one person company's AGM? That person only can participate in AGM. That is why he can conduct AGM at any time, any point. It may be bedroom or it may be bathroom or whatever room may be. He can conduct AGM at any point. Okay. Next, reappointment. Reappointment process, I have to complete this one. After that, rotation we will discuss. Actually, in handwritten notes, reappointment has been mentioned somewhere else. At the later point, I have mentioned, right? Okay. So, reappointment. So, in public company, 1/3 of the directors, excluding independent directors and nominee directors, are liable to retire by rotation at every AGM. Reappointment process, the retiring director may be reappointed or replaced by someone else. There is a possibility. Shareholders may reject this person, or shareholders may reappoint the same person also for the position. So if the company fails to do either Either means two jobs. So company didn't expressly reappointed the retiring director, or company failed to appoint some third party in the place of the retiring director, then and no resolution is passed, then the retiring director is automatically reappointed. The retiring director is automatically reappointed unless he is not qualified. Say for example, he is disqualified, ma. If he is disqualified, he should stay out of the company. Point one. Point number two, he has given written unwillingness. Written unwillingness means, say for example, one person in writing, one director in writing expressly communicated to the company saying that, sir, please don't elect me. I'm not willing to continue as a director in your company. Please don't elect me. Like this written unwillingness, this person didn't submitted any written unwillingness, then he will be automatically reappointed to the directorship. Why? Because no specific person has been allocated or appointed in the place. Company didn't pass any resolution. That is why the same retiring director will be automatically reappointed into the same position. Next, third point, a resolution for reappointment was rejected. A resolution company plans to put, but the resolution has been successfully rejected by the shareholders, and company didn't pass any specific resolution to fill the vacancy. That place, last but not least, the place was not filled due to deliberate decision. Deliberate decision means intentional decision. Deliberate means intentional, kavalani, actively. Deliberate means consciously, actively, intentionally, wantedly, whatever the point may be. Okay, you are good at synonyms, huh? Okay, so place was not filled due to deliberate decision. If these are the cases, then automatically the retirement director will be reappointed to the original position. Sir, if any person appointed, you have to go out of the company. If you provide if you provide the unwillingness in writing form, you have to go out of the company. If you are disqualified, you have to go out of the company. And one person specifically appointed in your place, go out of the company. This is the process of reappointment. But this is not the important thing. This is the important thing. Rotation is the important thing, not reappointment. Let's talk about rotation of directors. So this rotation process is applicable exclusively to which kind of companies, ma? Public companies only. This rotation process is not applicable to private companies. If any private company wishes to implement this process, it can do so. But Companies Act is making these provisions applicable only to public companies. Companies Act excluded private companies. Even though Companies Act specifically excluded private companies, if any private company wants to implement these rules in their company, it is at their wish and will. If they want to implement, they can implement. No one is stopping them. Okay, but as a general rule, this kind of rotation mechanism is applicable only to public companies and except government companies. That means again, this rotation process is not applicable to government companies also. In case of government companies also, this rotation mechanism is not applicable. Calculation of rotational directors. Calculation of rotational directors. In this calculation, first take total number of directors. Total strength you have to consider. Out of that total strength, Amma, did we complete the discussion relating to classification of directors? Independent director is not included in this rotation, right? Why? Because we are considering the role of independent director as to express unbiased opinions. If we include the independent director in this sheet, in this rotation mechanism sheet, then what will happen? The decisions of the independent director will be biased only. Sir, how can you say confidently that if we include independent director in this rotation mechanism, he will take biased decisions? Why? Because in order to secure his position in the company, identity crisis will come. If he planning to secure his position in the company, then automatically what he will do? He will stop expressing unbiased opinion. He will stop acting in the interest of the company. He will start acting in the interest of the directors. That is why independent directors are kept out of this shit. Rotation mechanism. And nominee directors also excluded from this mechanism. Why? Because nominee directors are representing banks or financial institutions or shareholders, third parties. They are not representing the company. That is why they also kept out of this mechanism. And SSD. Tell me who is SSD? Small shareholder director. This small shareholder director also kept out of this provision, and you have to exclude these directors also. Additional director, alternative director. Why? Why we have to exclude additional director or alternative director? Why? Because why? Because they'll automatically vacate. Okay, that is somewhat correct, but conceptually that is not correct. Why? Because listen, we are excluding additional director and alternative director from this strength, from this rotational mechanism. Why? Because these two guys are not representing or not appointed by shareholders in the general meeting. These two persons are appointed by whom? Board of directors. Whoever are actively participating in the previous sessions or whoever are following from day one class, they will get to know the mechanism of additional director and alternative director. Appointment of AD, additional director or alternative director, will be happened, or the authority to appoint lies with BOD, not with shareholders. That is why these two guys you have to exclude. So whom you should exclude from the purview of rotational mechanism? Independent director, nominee director, small shareholder director, additional director, alternative director. From total strength, please deduct these directors. Whatever the result is there. Say for example, our total directors are 14, sir. 1, 2, 3. Only additional director is there, sir. Alternative director not there. Or additional director, alternative director, both are there. Okay, 14 minus 1, 2, 3, 4, 5. 14 minus 5, how much ma? 9. 14 minus 5, how much? 9. Now, rotational directors is equal to 2/3 of the total strength. Total strength here means 9, not 14. Total strength here means 9, not 14. Why? Because for that purpose only you have excluded ID, ND, SSD, AD, AD. ID means Idli Dosa, independent director. SSD, small shareholder. ND, nominee director. AD, Unkoka AD. Okay, so whatever the number is there, on that number you have to multiply the number with 2/3. Sir, if any fraction came, then what we have to do? You have to round off to the next number. Sir, what is meant by next number? Don't apply your mathematics knowledge here. So next number means next number only. Don't unnecessarily round off. So 5.1 means 6. In mathematics, what you will do? 5.1 means 5 only. Up to 0.5. If it is below 0.5, you will consider nearest number. Above 0.5, again nearest number. Okay, don't apply your mathematics knowledge here. Companies Act is specifically mentioning for the 2/3 mechanism. For the 2/3 mechanism, you have to consider next number only. 2.01 is also 3. Okay, so 5.16, 5.76, 2.2 means 3. Okay, next one. Retiring directors. Who should actually go out of the company? Who should actually go out of the company? Out of the 2/3, you have to multiply this with 1/3. For this purpose only, exclusively, in this case only, in entire Companies Act, you will consider nearest number only in this case. In any other case, you will consider next number. So in every case, you have to consider next number only. Any case. But in case of retirement, 1/3 mechanism is there, no? In that 1/3 mechanism only, you have to consider nearest number if you get any fraction. If you get any fraction, you have to consider nearest number. That means 5.1 means 5 only. 5.7 means 6. 2.2 means 2. Why? Because why relaxation has been given exclusively for this purpose means if we go higher, 5.1 means 6, 5.7 means 6. If we go higher, number of persons who should go out of the company will become high, right? That is why in order to reduce that, only exemption has been given for this retiring directors only, 1/3. In this one case only, the entire Companies Act, you will consider nearest number. In any other case, you will consider next number only. First of all, kindly understand what is meant by considering next number, what is meant by considering nearest number. Forget everything. Forget everything. First of all, kindly observe the examples. Forget everything. No need to bag any concept and all. Forget everything. First of all, what is meant by considering next number? 5.1 means 6. Usually in maths, what you will do? 5.1 means 5. But the law is, provision is saying that you have to consider next number irrespective of majority and all. 0.5 below or 0.5 above. Forget about that thing. Consider next number. So 5.1 means 6. 5.7 also 6. 2.2 means 3. This is what we mean next number. Next number. Nearest number means 5.1 means 5. 5.7 means 6. This is again 0.5 below, 0.5 above. Okay, 2.2 means 2. First of all, understand what is meant by considering next number and what is meant by considering nearest number. Do you really understand what is meant by considering next number and nearest number? And you have to apply next number concept in the case of 2/3 and you have to apply 1/3 nearest number concept in 1/3. The best way to remember is in entire Companies Act, you will never consider nearest number except in this case. So this is a unique case. Which case? This is a unique case. So you can remember like this. In case of retirement, retirement means the person has to leave the company, go out of the company. Sir, whether he will actually go out of the company or not depends upon these 4 cases. What are those 4 cases? Whether he has got any qualification or disqualification. Next, he has given any written unwillingness, a resolution has been passed or not, the place was not filled due to deliberate decision. So depend upon these 4 cases. Forget about these 4 cases for the time being. I am talking about this 2/3 and 1/3. Say for example, numerical example, total directors are 14 ma. 1, 2, 3, 4, 5, 5 members. 14 minus 5, how much? 9. 2/3 into 9, how much? Huh? 6, very good. 2/3. Rotational directors is equal to 6. Out of these 6, who should vacate the office? Who should go out of the company? Retiring directors. 1/3 into 6. 1/3 into 6, how much? So, 2 directors, they have to vacate, go out of the company. They have to go out of the company. So, if you got fraction, kindly consider nearest number. Retiring process will be generally considered by mutual consent. But generally, mutual consent is not obtained in practical way. Why? Because no one is ready and willing to lose the position. Why? Because if they lose the position right now, they don't know when they will be able to secure again another directorship in another company. It all depends upon contacts and relations. Who is ready and willing to lose the job? If you are acting as a director, how much earning you may get? 5,000 per month, 2,000 per month, like your stipend 1,500 per month, 2,000 per month, like that they'll give handsomely, they will pay. So who is ready and willing to forgo lose that pay? That is why mutual consent, on a rare occasion, mutual consent is obtained. No one is ready. Sir, if no one is ready, longest duration has to go out first. If the senior guy agrees for this concept, then okay. Sir, no one is agreeing for mutual consent or longest duration first also, sir. Mundu raado na tappa antunnadu atanu. So then you have to decide the outgoing directors by drawing the lots. చీటీ లేయడమే, పేర్లు రాసి లేసి. Okay, so by you can decide the outgoing directors by drawing the lots. Are we clear? So this is the whole process of retiring directors, or rotational and retiring. Rotational 2/3 ma, retiring 1/3. Tomorrow we'll consider and we'll communicate resignation. Removal also, there is a concept ma, a removal of director also. If time permits, tomorrow we can complete. Tomorrow Saturday, right? Friday. Okay, right. No problem. Friday, Saturday, every day. Right. Tomorrow we can complete resignation as well as removal also, if time permits. So tell me, what are the concepts we have studied today? Nothing. మీరు వీక్ అట్లా కట్టింది ఏమీ లేదు. అపాయింట్మెంట్, రీఅపాయింట్మెంట్, రొటేషన్ అంతే. అపాయింట్మెంట్, రీఅపాయింట్మెంట్, rotation. Appointment, FD, SD, completed. Next, what is the topic we consider after appointment? Reappointment. Okay, reappointment presumed on some cases. Tomorrow we will revise it again, no problem. Materials. Actually, I informed to give the old material. Old means no, December 2025, that batch only. Old means not 2 years back or 3 years back. And whatever the amendments are there, I'll be very proactive to communicate the amendments. So no need to do any research from your end. Is this faculty is covering all the amendments that are there? Yes, I'm the first one to cover the amendments. Why? Because law is not static. It is always dynamic, keep on changing. So no need to do any research on your own. I'll intimate. So December 2025 material fit for June 2026 also. Meanwhile, if any amendments came, I'll let you know. No worries. Next, rotation we completed. Rotation. Out of total strength of directors, what kind of directors need to be excluded? You have to exclude ID, ND, SSD, AD, AD. Whatever the remaining directors are there, out of the remaining directors, 2/3 must be rotational directors. That means, in other words, 1/3 may be permanent directors. 2/3 must be rotational. Minimum 2/3 must be rotational. Out of the rotational directors, that means out of the 2/3, 1/3 must go out of the company. So in this 2/3 calculation and in this 1/3 calculation, if you face any fraction, then what will happen? In case of 2/3 calculation, if you face fraction, you have to consider next number, not nearest number. But in case of 1/3 only, you have to consider nearest number. Which number? God bless you. So tomorrow we'll resume this discussion, right? Up to 6 only, right? Our time.